Oosterveld. I'm a professor of international law at the University of Western Ontario in Canada, and I'm so pleased to be with you here today. Now, I was supposed to give this year in review back in 2020, and all of you know what happened, of course, in 2020. And then I was supposed to give it again in 2021, and all of you know that this was canceled in 2021. And so here I am in 2022 presenting 3 years in review for your listening pleasure. It's difficult, of course, though, to summarize what has happened in international criminal law over the course of 3 years in 30 minutes. So I will selectively mention only a handful of developments. And at the end of my presentation, I'm going to call on you to supplement what I've just said with any developments that you feel that I have missed, that something that you were hoping to hear about, and we can have a discussion on those points as well. So let me just dive in. I will begin with the subject of the roundtable this year, and you won't be surprised to know that I'm focusing first on the Russian aggression in Ukraine. A number of the speakers at this roundtable have already provided detailed commentary on the efforts of Ukraine and with respect to Ukraine and the response of many states within the international community. And the speakers yesterday noted the unprecedented level of accountability-related engagement from the International Criminal Court and the referring states parties. I counted 43 on the ICC's website yesterday, which is 1/3 of the 123 states parties to the Rome Statute. Also, of course, domestic investigations in Ukraine and the start of prosecutions. The work of the Joint Investigative Team and Eurojust, the OSCE's Moscow mechanism, the UN Independent Commission of Inquiry on Ukraine. Countries such as my own have indicated that they're investigating under universal jurisdiction, and Ambassador von Skog mentioned yesterday that she views these as structural investigations deepening state practice on universal jurisdiction. The efforts of many Ukrainian and international civil society organizations to document atrocities or otherwise assist. Discussions around accountability for the crime of aggression. And of course, Ukraine's utilization of the European Court of Human Rights and the International Court of Justice. I'm not going to repeat what you've already heard yesterday, so I will only mention 2 themes with short digressions to another situation, that of the Rohingya from Myanmar, because it has interlinking aspects, as you'll see. My first theme is the case brought by Ukraine against Russia at the International Court of Justice, or the ICJ. While this is a case of state responsibility as opposed to individual criminal responsibility, this case should certainly be watched by international criminal lawyers, both in part because it's part of what people have called the accountability matrix with respect to Ukraine, and because it involves the interpretation of the Genocide Convention. As you know, Ukraine filed its application against Russia in the ICJ in February with a request for the indication of provisional measures. That is, its second case before the ICJ with respect to Russia, with the first one filed in 2017 under the Terrorist Financing Convention, and this second case filed under the Genocide Convention. The hearings for provisional measures in this second case took place in March, with Russia not appearing before the ICJ. However, it did submit correspondence objecting to the court's jurisdiction, though not official filings. The court then rendered its indication on provisional measures completely in favor of Ukraine on the 16th of March of this year, including an order to Russia to immediately suspend its military operations on the territory of Ukraine. And as is clearly evident, Russia is in breach of this order, given its prolongation and exacerbation of the conflict on the territory of Ukraine. And this case is now at the memorial submission stage at the ICJ. I want to mention an interesting procedural issue. I mentioned a moment ago that there are over 40 ICC states parties that have referred the situation of Ukraine to the International Criminal Court. But in parallel, in July, 43 states, including the United Kingdom, the United States, European Union states, and the European Union itself, Australia, Canada, and others, issued a joint statement reiterating their political support for Ukraine's case against Russia in the International Court of Justice under the Genocide Convention. And in addition, a number of those countries and organizations have indicated that they are more formally intervening in the ICJ in that particular case under Article 34, Sub 2 of the ICJ statute and or Article 69.2 of the Rules of the Court. This list includes the United Kingdom, New Zealand, Lithuania, Latvia, and most recently, just over a week ago, the European Union. And I suspect that this list will continue to increase. Now, for those of you who are not immediately familiar with the rules of the ICJ, Article 63 of the rules grants a right to states to intervene in a contentious case when they are a party to a multilateral treaty that will be interpreted in the court's judgment, and in this case, that's the Genocide Convention. Now, some commentators have pointed out that it's unclear at this moment in time whether states can in fact intervene in this way before the Ukraine case in front of the ICJ, because in their argument, the court has not yet concluded that it has jurisdiction to proceed on the merits. And for those of you interested in this sort of procedural wrangling, you should look at the interventions filed by the states that and organizations that have already filed, because a number of them have addressed this issue head on, arguing that indeed they are permitted to do so. But this could be an issue discussed before the ICJ. Now, this sort of intervention is not unprecedented. Canada, the Netherlands, and the Maldives have indicated similar interest in the Gambia's case against Myanmar regarding genocide against the Rohingya before the International Court of Justice. And the reason why I mention this is because it seems to indicate a significant shift towards viewing the International Court of Justice as a valuable adjudicative tool, or adjudicative body, in cases of mass atrocity. In other words, as another important tool in the toolbox of accountability for international crimes, for genocide, for crimes against humanity, for war crimes. And this hasn't always been the case. This hasn't always been the view of at least some states with respect to the ICJ. And since I mentioned Gambia's case against Myanmar and its interplay in some respects with the Ukraine case before the ICJ, let me update you on the current status of the Gambia case. The case was instituted by the Gambia in November 2019 with provisional measures hearings in December of that year, so similarly speedy as in the case of Ukraine against Russia this year, and with an order by the court indicating provisional measures in January of 2020. In July of 2022, so in July of this year, the ICJ issued its ruling rejecting all 4 of Myanmar's preliminary objections. So now the case has proceeded to the next stage with Myanmar's counter memorial, so written submissions, being due in April 2023. So I'm now going to turn to my second theme under this discussion of the Ukrainian situation. A number of speakers yesterday noted the large number of accountability actors that are present in and around and with respect to the conflict in Ukraine. And this has created both benefits and certain challenges. I'm going to give you an example, but before I do that, I'm going to go back in time and refer to the Rohingya situation once again. So as you know, in August of 2017, the Myanmar army launched a systematic, brutal, and organized attack against the Rohingya population living in northern Rakhine State, forcing huge numbers of Rohingya to flee Myanmar for Bangladesh and elsewhere in a short period of time in response to this state-sponsored violence. Since then, many actors, media, aid agencies, non-governmental organizations, various branches of the United Nations, International Criminal Court investigators, academics, and others have traveled to Cox's Bazar in Bangladesh to gather information and to document conflict-related sexual violence that occurred in Myanmar. Many of those actors have recorded incidents of how rape and other forms of sexual violence have been used by the Myanmar military as a widespread and systematic weapon of war in order to instill terror and humiliate women, girls, their families, and their communities. They documented gang rape of very young girls all the way through to very elderly women, sometimes with implements like knives, often committed in public and in front of family members for maximum psychological impact. These actors have also documented that these effects didn't end when the Rohingya refugees crossed the international border into Bangladesh, because in exile, these refugees also face threats, stigma, shame, and pregnancies from rape. They also face risks like human trafficking, sexual assault, domestic violence, and rape in the refugee camps. And most importantly, for the purposes of my comments today, UN Women and others have indicated serious reservations about the viability and practices of those documentation processes, particularly dating back to 2017 and 2018, but not entirely resolved today. So for example, in 2017, UN Women noted that the stories of victims were being taken in a seemingly haphazard and uncoordinated manner, with no method to ensure that the victims were not interviewed on multiple occasions, with some reportedly interviewed many more than 10 times about their experiences. Raising, of course, the possibility and the actuality of the creation of prior inconsistent statements, and creating potential problems. Now, I'm speaking only from an international criminal law perspective, because of course there's the traumatic issue of having to recount your story many times, but creating potential problems for the use of such information by the International Criminal Court and other criminal justice mechanisms. As well, there was a failure of many of these actors to adhere to good evidence collection practices, especially the key ethical principles in the collection of sexual and gender-based violence. And these ethical principles are not just for international criminal law, they're for all actors, domestic and international, of do no harm and only document when honestly necessary. As the Murad Code puts it, and I'll explain this code in a moment, add value or don't do it. As UN Women commented about the situation in Cox's Bazar, quote, "At a more fundamental level, there is substantial confusion about the purposes for which organizations are collecting survivors' stories. It's unclear whether the purpose is to raise global awareness of the issues or to achieve criminal accountability. This not only raises expectations of victims unfairly, but makes huge assumptions regarding what justice means for this particular group." So let's fast forward to Ukraine. In March, in April, and onwards of this year. As someone with a keen interest in accountability for sexual and gender-based violence, I watched in mounting concern as a similar, initially uncoordinated rush to document sexual and gender-based violence took place, first and most especially by the media, who were interviewing victims over and over again and publishing their names, and then by others, including through electronic portals. However, as time went on, I also saw something different. Recognition by civil society organizations, governments, the United Nations, the International Criminal Court, which had already recognized this, and others, of the need to avoid repeating what happened in Cox's Bazar. While there's still some cause for concern that mistakes are being made in Ukraine that repeat the mistakes made in Bangladesh, there's also much, much more understanding of the need to ensure that any documentation of sexual and gender-based violence in Ukraine or of Ukrainian victims elsewhere must be done in a coordinated, trauma-informed, and victim-centered manner. This increased knowledge of this understanding of best practices stems from and can be linked to past efforts, such as the International Criminal Court Office of the Prosecutor's Policy Paper on Sexual and Gender-Based Crimes, the dissemination of best practices codes, including the issuance earlier this year in the UN Security Council meeting chaired by the United Kingdom of the Global Code of Conduct for gathering and using information about systemic and conflict-related sexual violence, more easily and more often known as the Murad Code, after Nobel Peace Prize winner Nadia Murad. The need for effective coordination of sexual and gender-based violence documentation was also highlighted in the outcome document of the July Ukraine Accountability Conference, which was mentioned by a couple of speakers yesterday, hosted by the International Criminal Court and the government of the Netherlands. This issue, of course, though, is ensuring that this understanding, this increased awareness, is translated effectively across all actors working on Ukraine. My next main point in this 3 years in review relates to jurisprudential, procedural, and political milestones. And I'm going to focus for the most part on the International Criminal Court, but acknowledge that yesterday you received excellent updates from prosecutors of other courts. Now, for the International Criminal Court, over the last 3 years, there's been quite a bit of activity, particularly as Prosecutor Bensouda's mandate came to a close and Prosecutor Khan's mandate began. One of the most important trial decisions of the International Criminal Court was in Prosecutor and Dominic Ongwen. That trial judgment was issued in February of 2021. It resulted in the conviction of Ongwen on 61 crimes against humanity and war crimes charges, which included, notably, the first convictions before the International Criminal Court on the crime against humanity of forced marriage as an inhumane act and forced pregnancy. Ongwen was sentenced in May 2021 to 25 years of imprisonment with time in detention deducted. And in sentencing, the trial chamber indicated that it balanced his abduction and childhood experiences within the Lord's Resistance Army as mitigating factors with his culpable behavior as an adult. The defense appealed the convictions, and that appeal was heard in February of this year. The appeals chamber followed its prior practice in some of its other cases by inviting submissions of amicus curiae. The appeals chamber identified specific areas where it wanted amicus curiae submissions because of the novelty, as they said, and the complex nature of the issues. They felt that amicus curiae observations would be beneficial for the proper determination of the case. And those issues that they wanted input on were, first of all, the grounds for excluding criminal responsibility, including evidentiary issues related to mental disease or defect, the burden of proof when asserting a ground for excluding criminal responsibility. So that was the first sort of category of amicus curiae briefs that they invited. The second category was on forced pregnancy and forced marriage. And lastly, on cumulative convictions. There were 19 amicus curiae briefs submitted, and of these, 10 were selected to present oral submissions. Michael Scharf mentioned yesterday that he appeared on behalf of the Public International Law Research Law and Policy Group, and I appeared on behalf of a group of international experts on forced marriage. And this process was quite fascinating, not least because of the interplay between the prosecution, victims' counsel, defense counsel, amicus curiae, and the judge's questions, but also because the judge's questions indicated that they were grappling with precedent-setting complex legal issues, including, on the forced marriage issue, the place or role of cultural approaches to conjugal relationships. That appeals judgment is likely to be issued in the coming months. Other significant jurisprudential developments at the ICC from the last 3 years include, but are not limited to, the March 2021 Appeals Chamber judgment in Prosecutor and Ntaganda, confirming Ntaganda's convictions on 18 counts of war crimes and crimes against humanity committed in the Democratic Republic of the Congo, and the confirmation of his 30-year sentence. As well, the opening of the trial in the Al Hassan case in July 2020, which is still ongoing. And this is the first case before the International Criminal Court in which persecution on grounds of gender is being directly considered. The March 2021 Appeals Chamber decision confirming the acquittals of Laurent Gbagbo and Blé Goudé in the Côte d'Ivoire situation, and the 2021 confirmation of charges and trial since April of 2022 of Abdel Rahman in the Darfur situation. This is the first case before the International Criminal Court in which crimes committed exclusively against men and boys have been expressly charged as gender-based crimes, in the recognition that the targeting of men and boys in Darfur was not only gender-related, it was at the intersection of political, ethnic, and gender grounds. I also want to recognize the increased cooperation between Sudan and the International Criminal Court's Office of the Prosecutor in the Darfur investigation and cases, with the prosecutor presenting his most recent report on the Darfur situation from Sudan to the UN Security Council just a few days ago. This is the first time the prosecutor has presented an update directly from a situation country, and just a few short years ago, this would have been absolutely unheard of for the prosecutor to be able to even set foot in Sudan. So the beauty of a permanent International Criminal Court is that it can wait for changes that allow individuals to be turned over or surrender themselves many years after the events and indictments. I also also want to mention the December 2020 decision in Lubanga approving the implementation of collective service-based reparations for victims. And of course, the prosecutor has expanded the geographical scope of investigations to, for example, Georgia, Afghanistan, Palestine, the Philippines, Ukraine, and Venezuela. And on the political side, I did want to mention, since I'm in the United States, that in June 2020, then President Trump imposed economic sanctions and visa restrictions against International Criminal Court officials, including Fatou Bensouda, in response to the Afghanistan investigation. And thankfully, in 2021, the US revoked these sanctions, which should never have been imposed in the first place. You heard a number of important jurisprudential developments yesterday with respect to the International Residual Mechanism for International Tribunals, the Special Tribunal for Lebanon, and the extraordinary chambers in the courts of Cambodia, so I won't repeat them here. But I will add, though, that there have been developments in terms of important cooperation between the International, Impartial, and Independent Mechanism for Syria, often referred to as the IIIM, and national authorities, including in Germany, leading to domestic prosecutions and convictions of individuals for crimes committed in the Syrian conflict, including gender-based crimes. My final theme, my final focus for this year in review, or 3 years in review, relates to the funding of international criminal justice. And I know international criminal lawyers don't often want to think about things like funding, but if you've listened to me before, you know that I think it's incredibly important to mention it, to think about it, to consider it. These past 3 years have shown that there are very real struggles, both within tribunals that are funded by assessed contributions and those that are ostensibly voluntarily funded. I'm going to start with the voluntarily funded tribunals to give you the update. The Residual Special Court for Sierra Leone's 8th annual report in 2021 noted a number of different activities that court is undertaking. On the prosecution and registry side, for example, they responded to requests for assistance from a number of national authorities for information. They are continuing witness protection. They are monitoring the convicted individuals. They are maintaining the archives, and they're conducting outreach. But there also was a common refrain from all past reports. In fiscal year 2021, the United Nations had to provide a subvention of $2.5 million as a, quote, bridging financial mechanism. And the Residual Special Courts Oversight Committee and the court principals undertook ongoing efforts to fundraise for that court. This was all necessary as the Secretary General had appealed to every state of the United Nations, and the government of Sierra Leone had appealed to every African state in the African group, and came up very, very short. So, people like Jim and others had to undertake 74 bilateral fundraising meetings with countries to ask for their support, to vote in favor of the subvention in the UN's 5th committee, so that the special court's residual mechanism could survive another year. In 2021, the Special Tribunal for Lebanon was in the news because the registrar published a report that June indicating that the exhaustion of the Special Tribunal's funds was imminent due to a shortfall in expected voluntary contributions, threatening the viability of an appeal hearing in Prosecutor Almerhi and Onesi, and counseling the commencement of a second trial at the Special Tribunal for Lebanon, and prompting, somewhat expectedly and somewhat unexpectedly, the drawdown of the Special Tribunal for Lebanon. And some states provided voluntary contributions in response, but only if the tribunal would draw down and complete its work. The Special Tribunal for Lebanon's 13th annual report from 2021 to 2022 indicated that UN subventions help keep that tribunal alive as well, and that the 2022 budget, also funded by UN subvention and some donor funds, was 80% less than the 2021 budget, enough to get the court through the appeal I mentioned and to a transition to residual phase. The extraordinary chambers and the courts of Cambodia also required UN subventions since 2014. The most recent subvention is for $7 million US, to which voluntary funds are added. And here is why subventions are required for this tribunal. For the Cambodia Tribunal, voluntary contributions for the international component of its work have steadily declined, from 17.7 million in 2015 to 13.1 million the next year, 2016, to 9.4 million in 2017, down to 8.4 million in 2018, to 6.2 million in 2019, to 4.4 million in 2020, and 3.9 million in 2021. So the percentage of voluntary contributions vis-a-vis the approved budget declined from 65% in 2017 to 38% in 2020. And this is due to donor fatigue, and of course was affected by the COVID-19 pandemic and the need for governments to divert funds elsewhere. On a positive note though, the government of Cambodia and partners supporting the government of Cambodia have maintained or increased a steady contribution on its part. Now, the Cambodia Tribunal will soon transition to its residual functions after the release of the final judgment by the Supreme Court Chamber on September 22nd in case number 2. And at this time, or after this time, the court will shrink dramatically, as will its budget, to an estimated $3 million. The realities of the Residual Special Court for Sierra Leone, the Special Tribunal for Lebanon, and the Cambodia Tribunal all demonstrate why a court created to be funded by voluntary contributions is not, in my view, a reliable or sustainable model. These struggles for adequate funding are not fully resolved, though, within courts set up on assessed contributions, such as the International Criminal Court. During the last 3 years, the ICC has also faced financial crises. Why? Because some states' parties are not paying their assessed contributions. The Committee on Budget and Finance of the Assembly of States Parties' most recent report of earlier this year indicated that as of the end of March of this year, there were 55 million euros outstanding in assessed contributions from states' parties. That's 36.54% of the ICC's budget. Only 49 out of the 123 states' parties had paid in full their assessed contributions by the 31st of March, and they're supposed to pay them by January the 1st. The committee noted that the liquidity situation of the court remains challenging because the way that they solved this problem in 2020 and 2021 is they got the states that always pay on time to pay early. So they paid 2 months early each year so that the ICC could use that money to fund the rest of the year. But what does that mean? That means, of course, by the end of this year, they will be 2 months out of whack, and there is a potential for liquidity crisis by December of 9.9 million euros. While this kept the ICC operational, it is creating a continual liquidity shortfall. The Committee on Budget and Finance has encouraged the Assembly of States Parties to consider what's considered strong action in diplomatic terms. First of all, to suspend the voting rights of delinquent states parties and not waiving those suspensions, because what's happened in past years is it's very politically in your face to suspend a state's voting rights, so they have then waived those suspensions. And the Committee on Budget and Finance is saying enough is enough, you need to keep those suspensions in place. And secondly, they have recommended that delinquent states should not be able to present candidates for elected positions. To close, I've touched on certain developments since the last roundtable with respect to Ukraine and the Rohingya situations, some jurisprudential developments, and budgetary challenges in international criminal law. There are many, many other developments, not least the shift to virtual justice during the COVID pandemic and various debates over international criminal law interpretations that I did not have time to discuss. But I'm now throwing it open to you. What have I not mentioned that you think I should have mentioned? Thank you. Is there anyone who wants to either ask a question or put forward thoughts on developments over the last 3 years in international criminal law? Yes.
Two questions, Valerie. One is, I'm not clear, what is the nexus between the Gambia and Myanmar in terms of the Gambia bringing a case against them at the International Court of Justice? That's my first question, so maybe answer that and I'll ask the second.
Okay. So Gambia has brought a case before the International Court of Justice against Myanmar on the basis of not being an affected party under the Genocide Convention, not being a state that's directly affected by the situation of the Rohingya, but of a state that is a party to the Genocide Convention that is interested in ensuring the rule of law at an international level. And it's permitted to do that. There's a particular category that for non-affected states to be able to bring such cases.
Thank you. That clarifies that. The other is there's been a lot of talk. I'm part of the NGO coalition for the ICC about voluntary contributions, and the coalition is having a lot of difficulty with that. They're not for it, because they feel that it takes away the state's responsibility to provide sufficient funding for the court, and also there can be, under certain circumstances, conflicts of interest. And so I wanted to raise that as well.
I think that everyone would agree that states parties first and foremost have the obligation to pay their assessed contributions in full and on time. And that would actually alleviate the liquidity crisis at the International Criminal Court and would assist in ensuring that all parts of the court have the funding that they require to do their work. Secondly, I think the prosecutor has been taking some efforts, particularly since his call for assistance with respect to the Ukraine situation, to ensure that voluntary contributions come into the court not earmarked for Ukraine, but to be used at his discretion for the work of the Office of the Prosecutor. So I think that's gone some way to help alleviate this situation. I do understand that voluntary contributions are not only cash contributions, they include personnel contributions. And I don't have any insight into that, but perhaps our deputy prosecutor might comment on that.
Thank you so much, and thank you for such an enlightening presentation. That was really excellent. On the issue of voluntary contributions, first of all, as you say, the contributions are being used across situations. And the note verbal that was issued to states made it very clear that we were asking for resources that went beyond Ukraine. For instance, we were asking for Arabic speakers and Spanish speakers. So it's perfectly obvious that we were looking to build our other team resources. Secondly, I think in terms of the secondments that have been offered to the court, they have also been distributed across pillar and across situations. But a budgetary issue that may arise in the future, and I think is a legitimate point for discussion, is what happens when those secondments end. Are we going to go back to the Committee on Budget and Finance and say, look, we've had this amazing help for the last 2 years with the secondments, now please find us assessed contributions to make up for the loss of the secondments? And the answer that the office has for that possible eventuality is to say that the role of the secondees is not just to help in the situations in relation to investigations, but also to help us to build our capacity. That capacity goes beyond the 2 years, so that the secondees are not going to go back to their countries, leaving a void behind. And a classic example of that is the secondees that we're getting on sexual and gender-based crimes. They will be attached, or they already are attached, those who have arrived, to the Gender and Children's Unit. The Gender and Children's Unit has absolute authority to decide where they go, to which team, and for each of those experts, they have a responsibility for training and capacity building. So we hope to alleviate this fear that there will be a void. Having said all of that, I'm sure that the demands of the office are not going to decrease as we open situations. And so then that leads us to the next issue of whether all our situations should remain open. Even after arrest warrants have been issued and not being executed, and where we really would not be investigating further. So that's a more difficult question, but it is one that is related to resources.
And another difficult question, of course, is that the actual approved budget for 2022, for example, was less than what the Committee on Budget and Finance had recommended to the Assembly of States Parties, and therefore reduced the ability of the Office of the Prosecutor to respond to all of the situations and investigations under its purview. So that larger political question of the relationship between the Committee on Budget and Finance and the Assembly of States Parties also needs some work. Yes?
Yeah, okay. Again, the concern is the Committee on, I mean, this is every year.
Yes.
The Committee on Budget and Finance has to understand that the prosecutor's office and others are, they're asking them to take on more responsibility, more cases, but they're not giving them the increased budget to deal with that. So the responsibility from the coalition point of view is that that's really where it belongs. And if these other contributions are coming in, then it's fine. So the Committee on Budget and Finance, then it depletes or deletes their responsibility, which is to increase the budget appropriately to cover extraordinary situations that occur, such as Ukraine, when they happen. I mean, these things will be happening.
Mm-hmm.
And if, sure, I mean, they'll be very happy to get rid of the responsibility if it's not good. But that's, from our point of view, is where the responsibility lies. So I don't know, Ms. Ott, whether you have any response to that kind of thinking or not.
Very briefly, I don't want to monopolize the conversation, but very briefly, I would say that this is one of the most vexed conversations that we have, and that is the way that we use existing resources, how predictive we can be, because we do not know whether we need to open a situation next year. Certainly, we could not have known that we would be opening Ukraine. And when we did open Ukraine, there was immediate reaction by the office, as you know, but it meant that we were taking people from other teams and putting them in the Ukraine team until, of course, we were able to use voluntary contributions and so on. So there are serious resource implications when we act according to the Rome Statute. I mean, I think that's probably the most honest way of putting it. If we are to apply the Rome Statute in the spirit that it is intended, if we open a situation when that is what the law requires of us, then we are facing budgetary difficulties. So, of course, we are involved in budget diplomacy with the Committee on Budget and Finance continuously. I've had meetings with the chair, and these have been very productive. And now we're going into the budget process. Up to the ASB in December, those meetings are going to be expedited, and there are going to be a number of them. But I think if we approach budget on the basis that we will always be required to open situations, therefore, we really need to build the capacity of the office to deal with every possible eventuality in terms of expertise. So we should not be left, for instance, in the doldrums because we don't have a financial investigator. And where we have a situation that does require investigation into the movement of money across borders, into bank accounts, possibly into bank accounts of countries that are not Rome Statute parties. So, if we're left with a gap there, then actually it's our fault because we didn't plan. So I think really it's a combination of our being predictive about what the way that we think the office will need to be paid, taking into account the possibility of opening situations we cannot predict. So it's a really, really hard call, and the prosecutor's going into this process in the next few months of talking to the Committee on Budget and Finance. But I have to say, we're going to be asking for an increase.
And understandably so. And I think that, if you don't mind, I'm going to link it to the larger issue of when states call upon international courts and tribunals, or call for the creation of new international courts and tribunals, but then they don't match it with action, budgetary action, continuous supportive budgetary action. Then there becomes this gap between the political and legal calls for accountability and the reality of how to accomplish those goals, which requires budgetary diplomacy. And I don't know if budgetary diplomacy is in the job description of the deputy prosecutor, but I know that back when I was at Global Affairs Canada and working on the creation of the Special Court for Sierra Leone, it was a surprise to David Crane and other prosecutors that budgetary diplomacy became sometimes 40% of the work that they had to do there and at other tribunals as well. Any other questions or comments? Yes?
I really appreciated your remarks earlier about the importance of making sure that evidence collection and working with victims is trauma-informed. And I was wondering if there has been discussion about or efforts to make sure that evidence collection is also disability-informed, especially given that disability tends to be more common in refugee populations, and of course over the past few years with the COVID pandemic, more people than perhaps ever before are experiencing illness in new ways that can make their experience much more harmful.
Yes, and within conflict, many disabilities are created, whether they are psychological or physical, mental or physical. The answer is yes, and in part that's because a feminist sensibility to understanding trauma-informed and victim-centered evidence collection and documentation of facts includes an intersectional analysis of age, disability, and other factors that will impact a person's ability to give, to wish to give, or to make an informed decision about giving information for the documentation purposes or evidence to an international or other court. So yes, there is sort of baked in, if I can put it that way, to the best practices codes an understanding of intersectionality that includes disability. We have about 5 minutes left. Yes.
I just wanted to mention, well, thank you first of all for that wonderful overview. I wanted to mention a few things from my perspective. One is the deepening of state practice around universal jurisdiction as a trend and the widening use of it. We've seen judgments just recently on Iran, Syria, Liberia. It's really a market trend in deepening that. And then the second is just to note a couple firsts from a couple newer and younger tribunals. Obviously, we can't mention everything, but one is the first conviction handed down by the Coast to Coast Specialist Chambers for witness and intimidation, not for the course substantive crimes. But then the second is the opening of the first trial by the Special Criminal Court of the Central African Republic.
Excellent. And on your first point, I think that this increased state practice in terms of domestic investigations and prosecutions has also prompted countries to look at their domestic legislation to make sure that they have that ability to do so.
Including the United States.
Including the United States.
This fall, for those of you who are interested, watch this space because there's draft legislation to amend our fairly curtailed war crime statute, amend our torture statute, and to propose domesticating crimes against humanity in U.S. law for the first time.
All of which would be excellent steps forward. Yes?
Do you want to comment? I don't know if you want to comment on the Kosovo, but just to add
Go
a
ahead.
footnote or a question. What are you seeing out there in terms of issues of witness protection? You mentioned it earlier as an imperative, and I've often said that it's sort of the soft underbelly of our system because it is so easy to intimidate individuals. And I'm starting to see this now in sort of two communities. You have vulnerable recipient witnesses, survivors, often who are the victims of the acts that are subject to prosecution. But I think courts are increasingly having to rely on insiders and defectors. And how are we dealing with those people who are not necessarily the most sympathetic of characters in some cases, and they may be defendants in other situations because they are somehow complicit in the events in question? Just curious what you're seeing out there.
It's hard for me to comment on any trends with respect to insider witnesses because from my experience at Global Affairs Canada, the plans with respect to their witness protection are confidential and rightfully so that they are not tracked down and killed by those who are upset that they turned insider witness. What I have seen, though, is an increase in prosecutions with respect to interference with witnesses, but also a seeming continuation of interference with witnesses. So let me just refer to the Special Court for Sierra Leone as just one example. There are many examples. This is a live issue that continues. So there are some who say, oh gosh, the special court's been closed since 2013, and so why do we have this residual special court? The victims are still at risk, and even the convicted individuals are sometimes seemingly involved still, or their families or their extended groups are still involved in tracking where victims are and sometimes threatening those victims. So the residual courts, if I can kind of make a larger point, are absolutely necessary, and this is why my point on funding is so important, because even though for example, the Special Court for Sierra Leone's substantive work in terms of prosecuting individuals is done, this victim protection aspect, as well as other aspects, will continue for quite some time, for a generation, for 2 generations. Yes?
Maybe to supplement on that, you probably know the mechanism in The Hague. We had a big contempt case arising out of a request for review, also during the talk now. And I think you're right. As long as there are people still serving their sentences, we have to remember they have a possibility of seeking a review of their convictions. And what we've seen is interference with witnesses to have them recant their testimony.
Yes.
And I mean, we are responsible for that investigation. It's, I wouldn't say spiraled out of control, but it turned out to be quite an endeavor. And we ended up with 5 accused. So we had a review hearing that overlapped with an investigation and turned into a contempt investigation. And as a spillover of that contempt case, there's an order for investigation of the defense counsel. And in the Buka case, there's some order already an investigation of a normal defense counsel. And I think this comes back to we have to realize that what have been established with all these definitions actually is not just a court, it's a judicial system.
Yes.
With sentencing enforcement and ensuring long-term upholding of the result of these courts. So I think you're absolutely right. This is a long-term endeavor, and I understand state struggle because the proactive work of the ICC, and at the same time, there's a need to be able to actually uphold the results of the other courts that cannot have wound down, and everybody will go, okay, we're not spending money on something else. But if you're not continuing to invest in the past organizations, you actually risk undermining the results that we make.
Exactly. I think that's a perfect note to end on because I noticed that it's now 10 o'clock, that our commitment to international criminal justice cannot simply end. It has to continue in order to solidify the work that's been done in the past and to allow the work that is going on now and in the future. Thank you very much for coming today.